Hello and welcome back to part 2 of the East Carolina Law Group Self-Help Series, and this is part 2 of our terminology section. So if you were just watching the previous part 1 of the terminology, we're just going to pick up where we left off. So hopefully everybody's kind of had a chance to digest. And so the last term we talked about was affirmative defenses. And there's one in particular I want to mention. The reason I want to mention this one in particular is because this is a very important one to know. This is important to know for a couple of reasons. One, it's common. Okay, it is common. And when I say common, it's important because many times when we see pro se parties in district court, they're normally there for domestic violence protective orders. Now, what is a domestic violence protective order? Well, we talked about this in previous videos, but basically it is an order of domestic violence that keeps another party away. It also can give you temporary possession of a marital home, temporary possession of a vehicle, and also custody. It can give you temporary custody of children. Now, that is extremely important. And the reason is because by statute, the normal civil custody and divorce and equitable distribution statute is Chapter 50 of the North Carolina General Statutes. Chapter 50B is the domestic violence statute. Now, that may not mean anything to you, but the reason I bring it up is because of this. In every case, there's what is called a standard of evidence. And a standard of evidence is basically what level of proof do you need to prevail. Now, in a Chapter 50, custody, custody, equitable distribution, alimony, so on and so forth, and a domestic violence complaint, the standard of evidence is the preponderance of evidence or greater weight. So academically, 51%. Tip the scale 51%, you're going to win. Okay. The standard of evidence in a DVPO, domestic violence protective order, and a Chapter 50 custody case are the same. Also, generally speaking, if the children involved have the same father, mother, whatever, and they're the same parties, the allegations and the parties are the same, the claims are the same. This brings us to a very important affirmative defense. And it's one that you need to know about, especially for those of you who are contemplating filing a domestic violence protective order, or who have filed one and are waiting to go to court, or who are filing a custody action. That term is estoppel. Estoppel means you're done. You can't bring it. Okay? There are two forms of estoppel as affirmative defenses: res judicata, or claim preclusion, or collateral estoppel, or issue preclusion. Now, you're not going to be able to preclude a claim for custody. That, as a matter of public policy, is not there. But what is there is issue preclusion. So let's say you are a pro se party, okay? And let's say you and your significant other get into an altercation, and your significant other has a history of suicide threats, drug use, smacking the children around, and beating up on the dog. These are actual claims people make. And you go to the magistrate and you file a pro se domestic violence protective order complaint. Now, let's say the magistrate gives you an ex parte order, which is a temporary order pending a merit hearing. If you go to that merit hearing and you lose, all of those allegations and claims that you've made cannot subsequently be brought in a custody action. They are barred by estoppel. So, before you contemplate using a domestic violence protective order as a free custody order, think very carefully. Because if you have 4 or 5 viable claims supporting factual allegations that support your custody claims, and you bring them yourself and you can't prove them by the greater weight of the evidence and you lose on the merits, those claims are precluded from coming in a subsequent custody hearing as a matter of law. It's very important. So that's why I wanted to touch on this particular issue as an affirmative defense. Be careful. hire a lawyer. Even for the DVPO. If it's solid for the DVPO, you can use estoppel the other way. You can use it offensively. If you hire an attorney to go in and litigate a custody or a domestic violence protective order, and they can prove those 5 things of abuse and suicidal tendencies and kicking the dog and all those sort of things, and they can prove those and it gets into an order, now you have judicial record. You have offensive claim preclusion. In other words, the other side can't subsequently come into a custody case and say, those things didn't happen. Well, they did. They were proven. Same standard of evidence, same parties, same claims. Very important to know those things. All right, so we're going to get back into some more of the common terminology and the procedural side of things. A motion in the cause. What's a motion in the cause? Well, a motion in the cause is basically any motion that's going to bring you back before the court. But generally speaking, these are when you're going to have a contempt hearing. You'll file a motion in the cause where you're going to have a claim for contempt, or sometimes you want a review on a custody hearing or a modification. You'll file a motion in the cause. Okay, but most commonly, you'll find them in contempts. So that's a motion in the cause. If you get one of these, red flag should go up and the phone should be picked up and you call an attorney. Motion to dismiss. Motion to dismiss is also extremely common if you, say, are the plaintiff in a case and you file a complaint for breach of contract or for personal injury or anything like that. You should expect to see a motion to dismiss. It's almost like getting a free box of fabric softener with your laundry detergent purchase, a free sample. Okay, they just happen. Every attorney worth their sand is always going to file a motion to dismiss under 12b-6 because you have to. And if there's an issue, it preserves it. Okay, an affidavit of service. Now, in the first segment, we talked about process and service of process. But what is an affidavit of service? Well, in North Carolina, that makes it different from many other jurisdictions is that we can actually serve process by certified and registered mail. However, when you do that, there are certain timing implications that come into play under Rule 6. Additionally, there's an affidavit requirement, which also has its own timing requirements of when that has to be filed before a hearing. And there's certain things in the affidavit that have to be completed. But just know, especially if you're representing yourself, if you don't know how, when, or why to do an affidavit of service, hire a lawyer. If you get a bill from your lawyer that shows that they drafted, prepared, and filed an affidavit of service, now you know what it was for. You must file that affidavit of service, otherwise you don't have good service. Verification. What is a verification? Well, in North Carolina, again, unlike many other states, in family law cases, a verification is an affidavit by the pleading party that the allegations contained, to the best of their knowledge within the body of the pleading, is true, except as to those things pled upon information and belief. If you receive a complaint and there's all kinds of allegations in there, don't come running into an attorney's office saying, this is all lies. If you're going to represent yourself, don't go running into the court and say, this is all lies, this is fraud, this is slander. Wrong, wrong, and wrong. The pleading standards are minimal, okay? They're minimal pleading standards that you need to make out a prima facie claim. And if you see allegations that say, upon information and belief, then that just means that they have this is what they think, but they don't necessarily have proof. And they're not saying that this is fact, but this is what they believe. So just understand that. But the verification basically says that if you, as the receiving party, fail to plead, technically they can have that complaint admitted as an affidavit in lieu of testimony in support of what's called a motion for judgment on the pleadings or summary judgment. Those are terms of art, and we'll probably cover those in a later date. We're not going to go over those now, but a verification is very important. Just know this. If you hire an attorney to do a divorce or a custody case or something along those lines, equitable distribution or something, chances are they're going to call you and they're going to say, hey, I need you to come into the office, sit down, review your pleading, sign and verify it. Don't say, send it to me and I'll let you know if it's okay. Don't do that. go see the attorney, sit down in the office, go through the pleading, because if there's things that need to be changed, it's easier for you to point them out, fix them on the spot, and then have a ready complaint to be verified and filed. All right, the next 5 terms we're going to discuss in the process. So after pleadings are filed and defenses are made and answers, so on and so forth, and service of process is done and affidavits have been filed, the next step in the process is going to be discovery. Okay, now after all the motions, the initial motions and things are disposed of, discovery will commence. What is discovery? So discovery can actually become in 2 flavors, and we like to use a lot of what I call informal discovery. Now, especially in our family and custody cases where you've got a split, I generally tend to find that one party pretty much knows everything that's gone on in the family, and the other party probably pretty much knows nothing. And if I'm fortunate enough to have the former, then I will usually task them to start getting these things on their own rather than requesting it from the other party, which is going to be time-consuming, expensive, laborious, and probably not bear a whole lot of fruit. So if you have a good attorney who's engaged in your case and moving your case and pushing your case, you should be getting homework. And if you're not getting homework, get in touch with your attorney and find out why. Okay? Some attorneys don't like their clients to do a whole lot of anything. We, on the other hand, like to keep our clients engaged, and we'll make you a very vested part of the litigation process. Anything we can get you to do that's not going to cost you an arm and a leg, and in legal fees and that sort of thing, we're going to get you to do those. So discovery is where we share information. We obtain information. It may be informal. We may use other sources. We may go to public records. I may send staff members out to your property to take photographs. That's all part of informal discovery. On the other hand, let's say you've been ousted from the former marital home. You got to get back in there because we have to catalog and inventory and photograph property. We will we'll issue what's called a notice of entry and inspection, which I believe is down here at the bottom. And then we will have a date set aside where we'll be able to enter the property, photograph, and do what we got to do. So that's part of the discovery process. Additionally, there's written discovery. Written discovery can be in the form of interrogatories, requests for production. Now, interrogatories are like short answer questions. So you'll get a question that says, list all addresses you've resided at in the past 5 years by date, address, who you lived with, how much you paid, so on and so forth. That's an interrogatory. Request for production of documents may be produce for inspection a true and accurate copy of your tax returns for the last 5 years. That's an example of a request for production. Now, under the rules, you can do 50 of each, unless the court gives you leave for more. There's also what are called requests for admissions, and these are kind of like true-false questions. They're admit or deny. And so they're kind of like leading questions, and it's important that you answer them fully, because if you don't answer the question or if you skip one, then it's deemed to be admitted, and that could be a bad thing. Deposition. A deposition is testimony that's taken outside of court. Usually for this, deposition will be noticed, and a court reporter will be retained and hired, and the parties or the witness or whomever will be brought to a location, usually within the county where the action is pending, and they will be examined under oath, and a court transcript for deposition will be prepared and can be presented to the court in lieu of their testimony. Or, in other strategic uses, deposition can be taken for the purpose of later testimony to impeach a witness, meaning catch them in a lie. So, that is basic terminology with discovery. So once the discovery is done, there's some other things that are going to happen, but this leads you up into the hearing and trial process. So the first thing is notice of hearing. What is a notice of hearing? Well, this is actually a formal document that's prepared that gives notice to whomever that a hearing on a motion or a complaint or a trial has been set. So if you receive one of these, you will be going to court. Don't not show up. An objection. So this is going to get us more into our rules of evidence. And this talks about at the trial process, okay? So during the trial process, one of the things that most folks, brand new law students, new lawyers, pro se parties, lots and lots of people love to throw around is relevance. And I know I'm jumping right to the bottom, but Relevance is probably one of the dumbest objections that you can make, because unless somebody is testifying about the alien space shuttle that landed at your house 10 years before the custody case you're in there for started, that's irrelevant. Relevancy is a very low standard. It's whether something is fairly probable, and whether the thing asserted is fairly probable, and whether it is going to substantiate your claim in any way, basically in any way, shape, or form. It's an extremely low standard for relevance. So relevancy objections are pretty much dumb. I'm not going to really go into the bar exam answer on what relevance is. It's really not worth your time. Okay, but relevance is an extremely low standard. I've had people go into court, especially pro ses, that'll start testifying about, 3 years ago this happened and that kind of thing. And the impulse is objection, relevance, but it could be relevant. I mean, could the thing they're asserting lead to, is it connecting something up that's going to be viable in that case? Normally, the real objection people want to make when they think of relevance is not relevance. It is foundation. Have they laid a proper foundation? In other words, connecting it up, just like we talked about. So, is there a foundation for this? She has been keeping the kids from me. Objection, foundation. Sustained. Okay, so then you got to get into, on such a date, I tried to see the kids, she said no. On such a date, I tried to see the kids, she said no. Now you're laying foundation, and now those things will come in. This is why most of the time when pro se litigants go into court and they try to litigate their own cases, and then they come to me and say, oh, that judge was a jerk because they wouldn't listen or hear or look at any of my evidence. It's not evidence yet. First thing you got to do is establish foundation. And that's almost always where pro ses fail. They cannot lay a foundation. They don't know how. Foundation is different for every piece of evidence, which is why you have attorneys who go through hours and hours and years of school to learn how to do this. And hopefully during that school time, they spent time interning with an attorney, going to court and watching and seeing how this stuff works. Because that is invaluable. Okay, hearsay. Hearsay. This is one. Every time I encounter a pro se party or somebody who's tried to represent themselves and they just don't get it, they kept saying this was hearsay. An out-of-court statement sought to prove the truth of the matter asserted is hearsay. Now, there are exceptions and there is non-hearsay. We're not going to get into those. Generally, an out-of-court statement offered to prove the truth of the matter asserted. The declarant is not in court. Now, if the declarant is the opposing party, generally the court will allow the statement so long as the opposing testimony is going to corroborate the statement. However, if you go to court and say so-and-so told me, it's hearsay. Out. All right? So if you're going to court and let's say you're trying to do your own custody case, and you go to court and you say, my daughter doesn't want to see her father. Well, how do you know that? Or objection, calls for speculation. And the court's going to say, sustained. You're going to say, she's going to say, well, my daughter told me she doesn't want to see her father. I mean, this is actually a line of questioning I had in a case recently. My daughter doesn't want to see her father. Objection, calls for speculation. Well, my daughter told me. Objection, move to strike, hearsay. Sustained, you can't tell me what someone else told you. Well, but my daughter's not here. Sorry, you can't tell us what she said. Well, I know he's done this. Well, how do you know that? Well, the neighbor told me. Hearsay. Gone, out. So, again, before you go trying to litigate your own case, and we see this very commonly in situations where folks are trying to litigate their own custody cases, DVPOs or civil protective order cases, don't do it. Hire an attorney. You don't know how to lay foundation. You don't know how to get statements in. You don't know how to avoid hearsay. Get an attorney. That's my mantra. I know folks aren't going to listen to me, but at least you're going to be a little better prepared. All right, the last is an objection. Objections must be made. Now, let's say you are that pro se person and you're up there and you're litigating a custody piece of a DVPO and you're saying, she shouldn't have to see her father, mother, whoever because she wrote this letter and tries to hand it to the judge. First objection. What's your objection? Lacks foundation. Show them the document. Can you lay a foundation? Well, what do you mean lay a foundation? Objection, foundation. Let's say we get around the foundation. My daughter drew it or wrote it, gave it to me. Okay, well, objection, hearsay. Don't get angry at the other attorney. The attorney's job is to protect their clients and protect their clients' legal interests. You can't prosecute a case predicated on information from the ghost that never lies and only you can see him, which is actually an argument I've made in front of a judge before. We've had cases where pro se parties have come in and tried to throw all this information out there from these people who aren't viable, and sometimes the court will be a little liberal and let a few things in that they can maybe get around non-hearsay. They're still going to get in over objection. And then at the end, once they finally reach the zenith, I'll stand up and say, Your Honor, objection, move to strike, motion to dismiss. The entire case of the plaintiff is predicated on information obtained by the ghost that never lies and only they can see him. They have no witnesses here. Nothing has been witnessed by them. They've got nothing here. And the judge will go, unfortunately, sir or ma'am, I have to agree with defendant's counsel. You haven't been able to give us any viable evidence. And then that's the person that storms out, comes into the law office and says, I hate that judge because they wouldn't listen to anything I have to say. The rules of evidence are there for a reason. It's so that we don't have another Salem witch trial. It's so that the ghost that never lies cannot come in and prosecute you. So I hope that you found this to be informative. I know it was a little bit long, but this is information. These are basic terms. Again, not intended in any way, shape, or form to supplement a proper legal education or legal representation of a qualified attorney. It's to give you an idea of what you're facing if you, for whatever reason, you decide you're going to represent yourself. But more importantly, if you hire an attorney, because hopefully you've gotten that message enough, you hire an attorney and they start talking about these things and you're getting ready for trial, you're at least going to have some idea of what you're going to be facing and some terms that you're going to hear all the time. Some things that are getting thrown around. When you see your bill and you see 5.5 hours and you've paid over $1,000 for a complaint, well, what in the heck is a complaint? Well, then you go, that's part of the reason you go sit down with your attorney and review it and verify it, because when they hand you a 10 to 15 page document full of legal jargon, it's going to make more sense. So thank you for tuning into the East Carolina Law Group Self-Help Series. We hope that you found these videos informative and have been informational in helping you determine what your next course of action should be in your own particular situation. If you find yourself needing additional legal help, we're available, and you can set up a consultation by calling our office at 252-453-2273. That's 252-453-2273. Or you can look us up on our website at eastcarolinalaw.com, or you can find us on Facebook at the East Carolina Law Group. And we post regularly on there, sometimes almost daily. We put everything from new legal information to office closures and things of that nature. And we provide updates on things that are happening in North Carolina and in our local district. So once again, if you need to get in touch with us, it's 252-453-2273. The East Carolina Law Group, where your family is our priority.